Welcome to On the Chain.
Because we see this case that's been going on now for 2 years. And now they're saying that the SEC officials are using off-channel communication platforms for official business and they're not complying. So we know that they're not complying because their attorneys wouldn't even comply with judge orders in the case. When in the SEC v. Ripple case, the judge was requesting things that the SEC would do and they wouldn't do it. And so obviously there's some major issue across the board. House Judiciary GOP recent reports suggest that SEC officials are using off-chain communication platforms to conduct official business and are failing to comply with federal record-keeping statutes. What does that mean? How do they be held? How are they then held accountable? What will then happen? We don't know exactly, but we want answers. Who wants answers? Patrick McHenry and Tom Emmer. A lot of people want answers. They CC'd. Who do they CC? Nadler, Maloney, and Waters. Where's Waters? On the Financial Services Committee. Come January, guess what? No more. Say goodbye to her chairwoman position at the Financial Services Committee because she will be replaced, as will each one of these representatives that we have CC'd, that we see CC'd in this letter. All of them will be gone come January, which will be interesting to see. So here, dear Chair Gensler, according to recent reports, the Securities Exchange Commission is fining companies for communicating about business matters on personal devices. These fines are curious in light of your history of skirting federal transparency and records laws, as well as evidence that the SEC is currently using so-called off-channel communication platforms for official business. We write with questions about your commitment to transparency and accountability. Now, we see everything that they've done in the SEC v. Ripple case. Now, the ante's been upped. The ante's been upped again against them. The chair and the chair people, persons sitting on the SEC have really stepped in it. They've stepped in it over and over and over again. What is up with this? In 2013, this is to Gary Gensler, while you served as chairman of the CFTC, the Commodity Futures Trading Commission, the CFTC Office of Inspector General discovered, look at this, how you used a personal email account to conduct official business. And they said no. During an investigation into your handling of the collapse of the MF Global Holdings, found that you used your personal email 7,005 times to conduct official business related to that matter alone. Your defense to violating federal record-keeping requirements was that you apparently did not know how to access your official email at home. Come on. Come on. This is such a cop-out. It's such nonsense that, it's crazy. It doesn't work like that, but obviously it's very easy to claim I didn't know, can't, blah, 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 whatever it is. Recent reports suggest the SEC under your leadership is likewise failing to comply with federal record-keeping statutes, in particular evidence uncovered during the FOIA, Freedom of Information Act litigation suggests the SEC is failing to identify and produce records of official business conducted on non-email or off-channel platforms such as Signal, WhatsApp, Teams, Zoom, etc. Now, Zoom can be recorded. Teams can be recorded. They can then file all that good stuff away. Signal, WhatsApp, you can set it to terminate at will whenever you want it to. So they're saying, hey, you know what? Step up. What the heck is going on? Certify. Look at this. The SEC must practice transparency and accountability at breaches. So they're saying you're finding companies for communication on personal devices, yet they're doing the exact same thing and worse. Why? Because these are public officials. These people are responsible to answer to who? The people. Thank you, Patrick McHenry and Congressman Tom Emmer, Congressman Patrick McHenry, ranking member. A lot of stuff going on here. This is really, really critical, especially as we go through all the things that are unfolding in the SEC v. Ripple case. Very critical. All right, now here we go. Jake Chervinsky. We don't have to get into the history of Jake Chervinsky, but it's rare in the world of the SEC enforcement to see public outcry register on a federal court docket in the way we've seen from XRP holders since December 2020. And John Deaton deserves a lot of credit for that. And for this brief, I look forward to reading the SEC's reply. Now, one of the things that Jake is pointing out here is that this is probably the first time in history that retail investors have come after the SEC for infringing on their rights to invest, and really making a statement to say, SEC, the action that you've taken has caused billions of dollars in losses and damages, not just now, but into the future. What you've done is negligent and beyond. And so it's amazing that people all around the world are really putting their foot down and making this statement. All right, let's move on over here. So this was, I keep saying August, October 31st, crypto law breaking, just added to our document library. What? Motion for leave by John Deaton and the XRP holders to file an amicus brief in opposition to the SEC's motion for summary judgment plus exhibit. And there it is. And here, we're not going to go through the whole thing, but it is massive, right? Sherry says, replying to crypto law, John Deaton and SEC Gov, well said. John did well in pointing out the difference between a sale and the fact that the underlying asset would remain a separate issue in appearance. Where is that? Here it is right here. When an asset is offered and sold as an investment contract, therefore a security, it does not transform the underlying asset itself into a security, hence the orange in Howie, right? Oranges remain oranges and XRP remains XRP, digital code. Therefore, even if Ripple offered XRP as a security, which it didn't, related to specific transactions, and maybe in the very beginning, XRP would still remain exactly what multiple government agencies classified it as in 2014, 2015, and 2019, decentralized virtual currency. And there you go. It's over and done with. So that's it. So just like the SEC came out and said, well, in the beginning with Ethereum, maybe they were selling an unregistered security, but then it changed, and then the use case and blah, 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 blah. Now the SEC comes out with Ripple and they say, well, from the beginning of time, you sold XRP as an unregistered security. You had no intent and you have no use case. Not like Ethereum. Ethereum has full use case and utility and all this stuff, and the XRPL has no use case, no utility. Therefore, we see it as a security. Makes no sense, right? Now, the other part is that they sold as an investment contract, right? Offered as, and there's these different tenets of the Howey test. And when it comes to Gary Gensler, he looks at just one component and doesn't even look at the whole component of it. It's crazy. It makes no sense, but thank God for John Deaton, throwing this out there and showing the SEC that the SEC is misinforming. I want to say they're misinformed, but no, in fact, they're misinforming the people.
Are you down with OTC? Please like, subscribe, and click the bell to be notified when the next video drops.